their individual questions, and then I would beg the council's indulgence to make a statement, which I think will be helpful to you and to the members of the community at large with regard to the recount process.
Okay, go ahead.
Ms. Alter was the first speaker who spoke on this matter. She and I share a great passion for protecting the integrity of elections, and I'm thankful to her for taking the time to come here tonight and talk about this subject. In response to her questions, the original recount request was filed by Mr. George Marcineau, and in it he requested that she be allowed to be an observer. The BMC does require the request to be filed by a voter of Burbank. Secondly, the ballot count and the canvass are open to the public, and those are notified. We post notices, and they're open to the public. The 1% manual tally is also a public process, and it was held right here in the council chambers on that Thursday after the election. The 1% tally conducted actually represented 1.47% of the total ballots cast, which is more than required by Elections Code Section 15360, which requires 1%. She also referred to conversation with Mr. Finley, and she emailed me about that. Mr. Finley is Chief Counsel for the Secretary of State's office, and she was kind enough to provide his name to us in an email that she sent to me. In her email, she tells me that in a conversation with him, Mr. Finley has advised her that this substitution of voters after the close of the protest period would be acceptable pursuant to law. I do have a response from Mr. Finley, which I think would be helpful for me to read to you. And the response begins by saying, the director of the Protect California Ballots organization did not convey to you and may not have fully understood the information I gave her over the telephone. I stated that any voter may, within 24 hours after a recount requested by another voter is terminated, request a recount of ballots not recounted as a result of the original request. And that's basically the gist of the message. With regard to Mr. Muldoon, Mr. Muldoon, I apologize for not responding to you in writing sooner, but I have been working very diligently on researching the subject before I could make an informed decision. With regard to the 5-day protest period, the 5-day protest period is found in the Elections Code, Section 15620, and it requires that the protest period, which is triggered by certification, be for a period of 5 days. It does not request that we preclude Saturdays and Sundays. As to the cost of the recount, that is also set by law. That is included in Elections Code Section 15624, and it includes costs for recount boards, staff time, publishing costs, city attorney, consultants, security, and all materials used, and whatever the cost is undertaken to prepare for the conduct of a recount. The names submitted after the deadline, I will report to you in my statement. Again, our systems are always open to the public. It's very important to me that this process is transparent. As you well know, many Burbank voters have availed themselves of the opportunity to observe at any time during the process, including the canvass, including election night, ballot counting, and everything else. The deposit question, that was my error. This is a new process for me, and I apologize for that. The deposit is required to be made on the day that the recount begins, and I think that responds to the questions that they posed. Now I would like to take an opportunity, with your indulgence, to go over the chronology of this to help you understand how I went through this process and what I did to learn about the legalities. The results of the April 12th general election were certified on Friday, April 15th, 2011. This certification triggers a 5-day protest period, during which time any voter can request a recount as required in California Elections Code Sections 15600 to 15634. Minutes prior to the expiration of the April 20th, 5 p.m. deadline, a Burbank voter, Mr. George Marcineau, came into the city clerk's office and filed a request for a recount. The following morning, on April 21st, Mr. Marcineau called the city clerk's office and requested to withdraw his request for a recount. He was asked to please submit his request for withdrawal in writing, which he did several hours later. At this time, he requested consideration of allowing another voter to replace him. At 3:33 p.m. on that same day, Ms. Fronnie Lewis submitted a letter requesting to replace Mr. Marcineau with her name, and later that day, a similar request was received from Mr. and Mrs. Muldoon. Staff embarked on an extensive research of the Burbank Municipal Code, the California Code of Regulations, and the California Elections Code, and further consulted with our elections consultant, the City Attorney's Office, and the Chief Counsel for the California Secretary of State. The conclusion of our research found no law or code which provides for the substitution of names of the original requester past the protest deadline. Therefore, due to the lack of legal authority, the request for recount, in my opinion, is considered withdrawn. Our response to that effect has been sent by certified mail today to Ms. Lewis and Mr. and Mrs. Muldoon. The City Council has requested a report on the mail ballot process, which will be coming before them during the summer. The public will have an additional opportunity during that time to provide input to the Council on the process, as well as ask additional questions. In the meantime, and in an effort to rectify currently circulating misinformation following our relevant numbers pertaining to ballots cast in the general election, the City Clerk's Office received total ballot envelopes totaling 8,970. Of those, 5 of the envelopes were marked that the voter had deceased. 2 of them were primary envelopes. 1 was indicating that the voter had moved out of the county. 12 of them were unsigned, and most of these unsigned came in at the last minute on election night, so we would not have had an opportunity to contact those voters and ask them to come in and please sign their ballots, which we typically would. 3 of them were duplicate votes of people who had already cast a ballot. We had not received their ballot, and in the meantime, they requested another ballot, and one was issued to them. Obviously, voting twice is against the law, and we could not and would not accept those. There were also 11 of those were marked as spoiled, and as such, reissued ballots were sent to those voters who had marked their envelopes spoiled. And finally, rejected. There were 15 that were rejected, and they were rejected because the signatures on those envelopes did not match the signatures that are on file with their with the voter registration official, which is LA County Registrar of Voters, which totals total ballot envelope scanned of 8,921. Of those ballot envelopes scanned, 8,866 ballots were counted. The difference between the scanned envelopes and the counted ballots totals 55, which could include a combination of envelopes which were received without ballots enclosed and envelopes that contained primary election ballots. Once again, to reiterate, only 15 ballots were actually rejected due to the fact that the voters' signatures did not match those on file with the Registrar of Voters. I hope that this information has served to clarify questions or concerns, and as always, our office is available for voters who have questions or would like to clarify any part of our process. Thank you very much for indulging me the time to respond.
So did you actually do a hand recount? I'm not clear about that. No?
No, we cannot do a hand recount. The law prohibits us from opening any sealed ballot boxes except for the conduct of a recount or to conduct a manual tally. Obviously, you have to randomly select one precinct to conduct that manual tally, and that was done pursuant to law.
And that matched the computer?
Yes, it did.
Ballot, okay. Any other questions on that issue? Dr. Gordon?
Yes, thank you for that report, Mrs. Campos. I have a question. You mentioned you consulted or conferred with a number of authorities as an independent elected official of the city. If you have a legal question, do you have independent counsel that you can refer to?
I have sources such as the attorneys in the Secretary of State's office. I can also call probably the Attorney General's office. And also I have the services of the City Attorney's office available to me as well.
Right, but the City Attorney's office is another agency or element of the city government, and you're an independent elected office. So if you desire to consult with someone who is professionally and competent and legal in the field of election law, would you be able to do that presently?
I had the opportunity to contact the Chief Counsel in the Secretary of State's office in this particular instance in the course of my research.
Right. But if you desired as an independent elected official of the city to speak to an independent professional outside the government representatives in Sacramento or anywhere else, do you have that ability to do that?
The attorney that represents the city is the attorney that I would go to for advice. I'm not sure what you're asking. I don't believe I have the authority to hire an outside attorney if that's what you're asking me.
If I could just respond to that.
I was going to just defer to this.
Sure. If she felt uncomfortable with the advice we gave, our office, or if she didn't feel comfortable getting the advice from the Attorney General or the Secretary of State, which is what she contacted, she can come to the council and ask the council for authority to hire outside counsel. That's how it would work.
Ask for the authority by means of requesting funds to do so?
Funds and authority. You need both those, of course.
When you have the opportunity, could you please get the information from the city charter or code that would specify those directions?
Well, the city, as she indicated, the city charter says that her attorney is the city attorney's office. But like anything, if there's a need for additional legal advice, she would come to the city council, who makes those decisions.
Okay. Well, what you just referred to, I would be very interested in seeing that she would come to the city attorney for legal advice, and then the process was. It's obviously new. I'd like to see that when you have the opportunity. I appreciate that. Another question, Ms. Campos. I think you indicated there were a number of ballots that came in that maybe were from the primary, but it doesn't sound like those are necessarily rejected. So do you take the intent of the voter, or does it have to be the proper ballot in the proper envelope with the proper signature?
No, it has to be the proper ballot. This was the general election. The questions on the general election ballot were different than the primary. The law does not allow for us to take the intent from the wrong ballot.
Okay. So you needed the voter in the mail-in process that we just went through had to mark their votes on the proper ballot, have to be put in the proper envelope with their signature in order for it to be counted.
That's correct.
Okay. And thank you.
Thank you. Okay, on this issue, Mr. Brick?
Yes, Ms. Campos. Mr. Muldoon said that I realized after the election, Ms. Gabel-Luddy won by 86, and then was changed to 95 with additional votes. And I believe he made a comment that Measure M, something like 400 more votes. Is there any truth to that?
On election night, the only outstanding ballots we had were ballots that we could not verify on Tuesday night, and they were sent to LA County for verification. If you looked at the results, which are attached to your resolution tonight, you will note that there were 13 ballots.
So the 400 is not...
That's impossible. There were only 13 ballots, and I can look real quickly and
No, that's okay, but I'm saying Mr. Muldoon made the comment. I thought about 400 were added, and I didn't see it in the report. I don't remember reading about it, so there's no truth to that. Correct?
No.
Thank you.
Thank you. Any other staff response to public comment?
Yes, Madam